Good morning, Chief Justice Cady, members of the Iowa Supreme Court. This case concerns the statutory duties of a municipal zoning board of adjustment pursuant to both state law and city code and Iowa case law to issue a written decision in a contested evidentiary hearing held before the board where there were witnesses, testimony, as well as written exhibits entered before the board regarding a special use permit. Under Iowa Code Section 414.15, a petition for writ of certiorari from a board decision must be filed within 30 days of a decision by the board. In this case, the board issued no written decision. Further, under Davenport City Code, Section 1752.020, the city code stipulates that a decision be filed in the board's office and is a public record. Now, a public record, of course, means it's a written record. This case involves in issues of fundamental fairness.
Why does a public record, of course, mean a written record?
Under Chapter 22 of the Iowa Code, a public record is a written record. If you ask for a public record that is something created by a municipality, it's a written record.
Recording is a written record, or a recording is a public record, is it not?
Yes, a recording is a public record.
Didn't we have a case where we said that the court's docket, which is the official court docket that is found only on the judicial branch website, is also a public record?
Yes, I believe you have. In this case, there was no decision issued by the board after the contested case. Of course, there are compelling reasons for a board of adjustment who sits in a adjudicatory capacity to issue written findings of fact. The hearing before the board does not constitute a written decision. A written decision helps facilitate judicial review. It gives notice to the parties of what the decision was.
Don't we have kind of two issues here? I mean, one was the petition for certiorari timely? And the other issue is, if it was timely, was the form of the decision that was issued by the board, was it proper or not?
Well, the first issue involves the running of the 30-day time period. We were put in a catch-22 position here, Justice Mansfield, because we didn't have a decision. So the question was, were we filing too early to the district court, or were we filing too late? The board's non-action in this case created a trap for us because we had to decide how to proceed when the board was not going to issue any written findings of fact after an almost 2.5-hour evidentiary hearing before the board. We had 9 or 10 witnesses testify. We submitted 6 exhibits in support of revocation of a special use permit, and we were then in a twilight zone as far as trying to find out the board's decision. The district court dismissal of our appeal says that the board's oral vote on the 2 hearings in October and December of 2016 constituted a decision. We disagree with that, and we believe that the district court erroneously relied upon two Iowa appellate cases in support of that decision that were clearly distinguishable. The Arcay case, as well as the Christillis case. In both the Arcay and Christillis case, those decisions involved the time period a petitioner must file an appeal from a zoning decision to the zoning board. Of course, our case involves an appeal from a zoning board decision to the district court.
Well, which
It's
raises
an appellate review.
Yeah, well, it is appellate review, but isn't it a de novo review? Doesn't the district
It's-
court review that decision?
No, I don't think it's entirely de novo review, Justice. I believe that the first issue is whether there's substantial evidence to support the board's decision. And second, the board's interpretation of law is subject to the court's de novo review on whether the zoning board correctly interpreted the underlying zoning statutes. In this case, for instance, this court has held a long line of cases finding that there ought to be a written fact findings by the board for a district court to review. This was established back in 1979 in the Potawatomi v. Board of Adjustment case. And Justice Katie, you affirmed that in your 2006 authors of the City of Johnson decision, where you upheld a board's decision when it passed a written resolution containing 5 specific findings of fact that the board relied upon. And you held that that was constituted substantial evidence. Justice Mansfield, in your 2013 decision, Lang v. Lynn County Board of Adjustment, you found that the board made detailed findings of fact containing substantial evidence to support the denial of the ag exemption. This case is clearly distinguishable.
My hunch is that municipalities all the time do things without issuing written findings fact that they're supposed to make. It strikes me that that's a separate issue from timeliness. Your obligation as an attorney is to file a timely petition for writ of certiorari, and then if your petition is timely, you can then raise the absence of factual findings. What's wrong with that
I disagree.
analysis?
Number one, the statute says under 414.15, as well as the city code, that the time period for filing the appeal runs 30 days from the date of the decision. There has to be a written decision when there is an evidentiary contested hearing involving witnesses, exhibits, evidence presented to the board. The district court said the oral vote of the zoning board constituted the decision, that we had notice of that because we were at the meeting and we participated in the meeting. We believe that is clearly error under Iowa law. An oral vote by a board cannot constitute a decision for appeal.
What about the argument the city makes that you also have Rule 1.1402, which says that you have to file the petition within 30 days from the time the tribunal board or officer exceeded its jurisdiction or otherwise acted illegally?
Well, again, that implies that there is something to review, a decision to appeal. How are we supposed to challenge a decision when there's no adequate record on findings of fact? In this case, the only findings of fact that were made were by the staff before the hearing even occurred. The board simply passed or approved minutes of the meeting, and I believe counsel will tell you that he contends that The minutes of the meeting constitute a written findings of fact. Minutes of a meeting are required under Chapter 21 of the Iowa Code, the open meetings law. Every public body, such as a zoning board, has to issue minutes of the meeting showing who was present, the issues presented, and the votes. Minutes of a meeting are separate and distinct from written findings of fact. Written findings of fact have to be based upon the actual adjudicatory evidentiary hearing held before the board and what the evidence was. In this case, the zoning board's minutes of meeting do constitute no written findings of fact. They simply are minutes required under Chapter 21 of the open meetings law of the Iowa Code. We're in a situation here where we had to file an appeal to challenge the decision, but there was no decision by the board. The only public record of the board's meeting was publication of the minutes of the meeting on December 8th on the city's website on January 8th, 2017. We filed the appeal on January 25th, 2017, 19 days after the only notice that was publicly announced regarding anything in writing regarding the board's decision. The problem is if the appeal is made simply based upon the board's oral vote, as the district court said, then you're in a twilight zone as far as what the record and what the actual findings of fact are by the board. We believe that the board had dirty hands in this case because they did not issue a written decision containing findings of fact. And the Iowa Supreme Court clearly established that condition back in 1979 regarding what zoning boards of adjustments are required to do. Thank you.
Mr. Meloy, thank you as well. Mr. Marshall.
Thank you. Honorable Justices, and may it please the Court. In the 2008 case of Bontrager Auto Service versus the Iowa City Board of Adjustment, this court reaffirmed the holding that the requirements imposed by statute on an inferior tribunal must not be too technically construed lest its efficiency be wholly paralyzed. That policy statement and holding is at the heart of this case, where the court is being asked to interpret such a statute, Iowa Code Chapter 414.15.
Okay, well, here's the issue. The statute says within 30 days after the filing of the decision in the office of the board. I have some problem reading that statute to say that merely announcing an oral decision at a meeting fits within that statute. Do you?
No, Your Honor, I don't. And the reason is because the board didn't simply announce an oral decision. If you look at the minutes from the December 8th, 2016 meeting of the Board of Adjustment, or any of the minutes for that matter, they expressly incorporate the videotape of the hearing, which is about a 2-hour meeting, which goes over the arguments.
But that's not findings of fact. I mean, it's the record, I suppose. But you know, how does a party know precisely what the key factual issues? I mean, there were disputed factual issues, maybe, or maybe, you know. How does the party know exactly what to attack at that stage?
Well, in this case, again, the record is sufficient to allow that party to determine why the Board of Adjustment acted the way that it did. And let's just focus for a second, not even including the videotape of the hearing or the briefing that was submitted to the Board of Adjustment on these issues. Let's just look at the minutes.
Were there factual disputes and if there were no factual disputes, maybe factual findings aren't required. Were there factual disputes at the hearing?
There were alleged factual disputes. Under the Davenport Municipal Code, a Board of Adjustment, in order to approve a special use permit, or in this case, when they were addressing the decision whether to revoke a special use permit, has to go through certain requirements under Davenport Municipal Code. If you look at the minutes from the December 8, 2016 meeting, you'll notice that there are a recommendation and findings of fact included in those minutes. And the findings go through those requirements under the Davenport Municipal Code.
Here's my issue with the minutes, and I mean, maybe unlike some other members of the court, I don't have a problem with the argument that the minutes, when put on a website, could start running. But the problem is, when they were first put on the website on December 22, they're just proposed minutes. They haven't been approved. They're not approved until the next meeting, right?
No, that's not true, Your Honor. In fact, the December 8th, 2016 minutes, which is the minutes that are in dispute here, those were approved unanimously by the Board of Adjustment on December 22nd of 2016.
Okay,
And
yeah,
the
I
record
misspoke.
indicates that that's true.
All right, so they're placed on the website, but then when are the minutes as approved? When is the decision to approve the minutes placed on the website?
Well, there is no decision to approve the minutes that are placed on
Isn't
the website.
that in the minutes? I mean, I go to a board meeting and it always says the first thing we did is we approved the minutes from the last meeting. So when was that? When was the approval of the minutes of the December 8th meeting placed on the city's website?
On December 22nd of 2016. If you look at the minutes for the December 22nd, 2016 minutes, the first item on those minutes are the Secretary's report, which states the minutes for the December 8th, 2016 meeting were unanimously approved by voice vote. As of December 2016, there was no question, if there ever was a question.
But that piece of that information was posted on the website that same day?
No, in fact, those minutes, the minutes were posted on the city's website, and this is admitted by the petitioners in this case, on December 19th of 2016.
But how could you post an approval that didn't occur until December 22nd?
Well, the meeting minutes are the same. The meeting minutes that were posted with the agenda on the December 19th, which is when the agenda was posted for the December 22nd meeting. It contained the minutes of the board. Those are the same minutes that were posted on the December 22nd minutes. They didn't change. The board made no adjustment to those minutes.
No, I understand, but legally speaking, the minutes are not approved until the December 22 meeting. There's a one meeting lag. If you're going to say the minutes are the decision, the minutes are approved one meeting later, then the question is when is the outcome of that meeting posted on the website so that people in the public have notice in it? If we agree that posting something on the website constitutes filing of the decision in the office of the board.
Again, Your Honor, I think that there's a requirement. I think it's important to go back to the statute. There's a reason that there's a requirement that the minutes of the meeting, the records of the board, be made a public record. That wasn't just thrown in there. That's there for a purpose, and it's there for a purpose to put individuals on notice of the board's actions. So to say that the Board of Adjustment has to somehow send out, which is really what the plaintiffs are arguing, is that the Board of Adjustment needs to send out notices to every possible person who could have an interest in this case so that they're aware of what's going on in the Board of Adjustment. That's not what the statute requires.
No, but
I think Justice Mansfield's asking you is, does there have to be an official approval of the minutes once the board approves it at the meeting where it took the action?
I would say no. That's not what the statute requires.
the statute does say official decision, so how does
Well,
one
it says
know
a
that
decision. The statute
right,
says the
filing
filing
of
of
a
a decision in the office of the board. Now, when we interpret a statute, we give terms their plain and ordinary meaning. Well, what's a decision? A decision is concluding or resolving something after due consideration. It could also be defined as engaging in the act of deciding something, like a question.
What did the board do before there was a web page?
I assume that the board wrote out minutes like this, and instead of posting them on the website, it probably had a file cabinet in the basement of City Hall where it put these minutes.
So the minutes were probably not prepared at the same time the decision was made. There was probably a lag time of a few days, probably.
There was probably a little bit of a lag time. I think that's irrelevant. The decision was made on December 8th of 2016. The board, or the petitioners filed their petition on January 25th of 2017. The statute requires a 30-day period. If we go back 30 days, that takes us to December 26th of 2016. If this court finds that a decision was filed in the office of the board at any time prior to December 26, 2016, the petition is untimely. So it doesn't matter if the court finds that the decision was filed on December 8th of 2016 when the board voted and the meeting was adjourned. It doesn't matter if the court decides that it was filed on December 19th, that the decision was filed on December 19th when the petitioners acknowledged those minutes from the December 8th meeting were posted to the city's website. And it doesn't really matter if the court decides that the minutes were filed or the decision was filed on December 22nd, which is when the board unanimously approved the minutes. As long as it was before December 26th of 2017, the petition is untimely.
His view is it's not till January, even under this view that you can file things electronically, it's not till January 6th when you actually have an approval of the minutes that reflect the decision that was being posted on the website, where the minutes that have been approved are the ones from the December 8th meeting. That's their position.
That's their position, and we think that that position is incorrect, and it gets into this type of hyper-technical requirements that this court said we don't do in Bontrager. Now, in terms of a decision, I've talked about what the definition of a decision is. The question is, when was it really filed? And our position, the city's position, is that the decision, meaning that it made a decision, it took an oral vote, that decision was filed when the meeting on December 8th, 2016 adjourned. At that point, you had a couple things. You probably had either a typed or scribbled down notes of the board secretary, which recorded that decision. You also had a videotape recording available at the city, which included the board's decision, that vote. And the petitioners are arguing that, well, we didn't know what happened. There was no way for us to be able to develop an appeal based on the record. And I think that's a red herring. Nobody had to guess at what the Board of Review did in this case. Nobody had to guess at what the outcome of the Board of Review's decision was. The Board of Review clearly...
Here's where I have a little bit of a disconnect, I think, with this. You know, city government is meant to be transparent. And just as we've been talking about now for 15 or 20 minutes, all of it shows the confusion that was a result of this. And I understand we don't want to be hyper-technical and all this, but you know, just to get the basic decision out, to me, doesn't appear to be shouldn't be that big of a problem when we have to say, well, you know, you had the videotape, so they have actual knowledge of what the decision was, but we don't have any report or writing at that point. Then we have the minutes that are prepared sometime thereafter. Then we have the December 22nd where, okay, we approve the minutes, whenever they were prepared, and then there's still a question about whether that substantially complies with the statutory requirement. And so this is where I'm having a little bit of struggle with. It shouldn't be this difficult to make sure that the people who are disputing this know what, in one form or fashion, what the decision was of the Board of Adjustment. They know they denied it, but give me all the reasons so we can then take it and file our petition for cert and get it heard, and that we have a record of what's going on here. What is so difficult about that we have to now go through and all these patchwork of things to get a notice of a decision?
Your Honor, let me answer that question by going back to Justice Mansfield's point, which I think is really the crux of this issue. And that is, there needs to be a distinction made between the sufficiency of the board's findings and the filing of a decision for purpose of the running of the statute of limitations. Those are two completely different questions, and the petitioner spent a lot of time talking about something that isn't before this court. The sufficiency of the board's findings of fact and conclusions of law are not before this court. They
Yeah,
weren't
and I
preserved for
agree.
error.
We're strictly looking at the timeliness of it on the motion to dismiss, but, go ahead, I'm sorry.
So I'm just saying that it's a different question. Let me say this, the requirement of written findings of facts and conclusions of law as set forth in Citizens, the purpose of that rule was to allow a reviewing court to determine with reasonable certainty the basis upon which the board acted, the facts and legal conclusions upon which the board acted. That is a totally separate and distinct question as to the filing of a decision for purposes of the running of the 30-day statute of limitations. If the district court didn't even get to the question about the sufficiency of the findings of fact, and if the petitioners wanted to preserve that for error, they were required to file a motion asking the court to enlarge its findings to include a ruling on that issue, and they did not. So all that's before the court is not the sufficiency of the findings of facts. It's whether the board issued a decision and whether that decision was filed. And as I stated before, if those two things occurred, if the board made a decision and if it was filed any time before December 26th of 2017, the petition is untimely. And that's all that the court needs to decide today. It doesn't matter that the district court relied on Chris Chillis and RK. This court can affirm on any basis. And the city is asking that the court would affirm the district court's dismissal on the statute of limitations basis and find that the city did issue a decision when it voted to deny the petition, or when it was filed on the city's website, or when it was approved, or any other time that the court chooses, and deny and find that the petition was untimely. If there are no other questions. Thank you, Your Honor.
Mr. Marshall, thank you as well. Rebuttal argument, Mr. Meloy.
Thank you, Justice. Contrary to what counsel told you, there were clearly factual disputes in this case. We submitted, as I said, 10 witness testimony, written exhibits on the issue of whether a special use permit was ever issued to this particular commercial daycare center that was operating 24 hours a day, 7 days a week. And I listened to counsel, and he talked about supposedly us asking the court to find some hyper-technical requirement. Justices, there is no hyper-technical requirement here. There is a clear statutory duty of the Zoning Board of Adjustment. It's not the Board of Review, it's the Board of Adjustment. The Board of Adjustment is a quasi-judicial statutory creature of the legislature that reviews zoning decisions in a municipality. Clearly, the language of state law that says that there shall be a decision made by the board and filed in the office of the board, Section 414.15 of the Iowa Code requires the filing of a decision. Clearly, under the Davenport City Code, they have a requirement of keeping the minutes of the meeting is separate from the requirement of every decision shall be filed immediately in the office of the board and shall be a public record. Now, we disagree that the minutes of the meeting constituted any decision, Justice Mansfield, because again, if you look at the minutes of the meeting, there is nothing contained in the minutes regarding the board's findings of fact after the evidentiary hearing was held.
Where I'm coming from, Mr. Meloy, is that 414.15 just requires filing of a decision. It doesn't require the written findings and conclusions, and that's enough to trigger the 30 days to start running under the statute. So what you need to establish, at least for my satisfaction, is that there wasn't a filing of a decision 30 days before January 25th.
Well, we contend there was never a filing of decision because there was never a written decision issued by the board regarding the actual evidentiary hearing. There was the oral vote by the board. Counsel tells you that was a decision. We disagree with that. Then he tells you that the minutes were approved and that was a decision. We disagree with that because there's nothing, if you look at the minutes, there's actually nothing in there that the board decided. And third, he says that we missed the 30-day statute when the minutes weren't even publicly posted on the city's website until January 6th of 2017. We submitted an affidavit from John Lonigan in the district court regarding the motion dismissed, where he went to the board's office and he asked to look at the records of the board. And he was told there was no written decision issued in this case, and there was nothing contained in the records, not even the minutes of the meeting. They claim that because they passed the minutes and they were posted on the website, that constitutes a written decision in an adjudicatory, contested case, evidentiary hearing before a zoning board. A zoning board is acting in a quasi-judicial capacity. They have duties. They have to meet their duties under both state law and city code. Are there any questions?
Let me ask you a quick question. You had, under the code, you needed to file a writ assert, which you did, and the writ assert required you to identify the illegalities of the decision made by the board. How were you prejudiced in your ability to pursue your writ of certiorari without the written decision that you allege the board should have entered?
We were prejudiced because we did not know what the board found for their actual factual findings of fact, and we were prejudiced because the board is supposed to make legal interpretations of the municipal zoning ordinance, applying those factual issues to the actual zoning statute. So therefore, we don't know what the board actually decided, and it makes it difficult to challenge the board's action when council claims the board's oral vote constitutes a written decision, or the minutes constitute a written decision. It puts us in a never land of catch-22 of what the board actually decided, because the board didn't actually decide any legal interpretation of the code under the hearing the way it was conducted. Thank you.
Thank you as well, Mr. Meloy. The case of Burroughs versus the City of Davenport Zoning Board of Adjustment is now submitted, and the bailiff may adjourn.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.